Michael Popok, Legal AF After Dark, the 3-anchor edition. We talk about Judge Engoron's decision, the corporate death penalty, if you like, against Donald Trump and his organization and all his little Trumpers for up to $500 million, including interest. And the judgment has been entered now, and the clock is ticking on the appeal. We break it all down on Where Else? Legal AF. Take a listen.
But let's just break it down, and let's just start at the top with what happened in the New York Attorney General's civil fraud case. We've been waiting for this verdict to issue by Justice Arthur Engoron. And Michael Popok, I'll be honest, it even exceeded my expectations in its strength, not just with the monetary amount for the disgorgement remedy of $364 million when you add it all up, about $355 million or so with respect to Donald Trump. You add up $4 million for each of Donald Trump's adult kids, Don Jr. And Eric Trump. But also you talk about the other remedies, the additional powers given to the independent monitor, Barbara Jones, having to now install an internal compliance officer within the Trump organization, the other bans from Donald Trump and the Trump organization from obtaining loans from lenders certified with New York State. Michael Popok, would love to get your entire perspective on what took place there. And did it meet, exceed your expectations, and anything you think that people really aren't talking about, when it comes to this decision?
Thanks, Ben. Yeah, listen, I think we anticipated here on Legal AF a number of the developments. The dollar amount is almost exactly what Letitia James, the New York Attorney General, had asked for. The reason people are seeing different numbers, I'm going to start with the numbers, then I'm going to talk about the ban, then I'm going to talk about the other thing we anticipated was that based on reports from the monitor, who's been in place for 15 months, that there's still potential fraud going on within the organization while the trial was going on. There's going to be the creation of a new position of compliance director who's going to work hand in glove with the monitor who just got an extension of 3 years on her employment contract, all paid for by Donald Trump. But let me break it down. The numbers are varying mainly because of whether news organizations are compounding the interest of 9% for the years that interest is running on a prejudgment amount or not. When you add it all together, we'll just make it easy. It's pushing $500 million or more once the 9% compounded interest is running from the various states that are appropriate. The reason it was 92 pages, and I'll give you the key takeaways, is because the judge methodically went through 40 witnesses. He summarized the salient points of their testimony, both for the Attorney General and against where that was appropriate. He summarized, as the trier of fact, his evaluation of witness credibility, mainly the Trump kids, including Ivanka, not being very credible, nor Trump, and the lead financial, what we refer to here on Legal AF as the money man or the bag men for Donald Trump, which is Jeff McConney, who was the longtime controller, now disgraced. He just avoided being prosecuted for tax evasion himself. And similarly, Alan Weisselberg, put them in the completely not credible category, but let me continue with the remedies here. This was an equitable case. This is not a case about fraud. All of Donald Trump's supporters, including his own lawyers, they take the position that this is some sort of common law civil fraud case that needs certain elements proved in order for there to be a winning case. That is exactly the opposite. I'm sorry, most of these lawyers never practiced in New York like Karen and I do, but that is not what the Executive Law 63-12 requires. All it requires is, the 6 more counts of fraud that were proven, all that it requires is that there be a persistent fraudulent pattern or practice or a intent to deceive. And that's all. There doesn't have to be a victim. There doesn't have to be reliance, which is what we have to do in normal civil fraud. These are tremendous, robust powers that were given by the legislature in New York to the New York Attorney General, mainly because New York is the financial capital of the world. And almost, as the judge said, almost like a sovereign, they had a sovereign nation, if you will. The state, and therefore the Attorney General, has the obligation to regulate and make sure the playing field is level and that persistent fraudsters are put out of business. And that is the law that was applied to Donald Trump. That's why there's a judge, not a jury, as the judge reminded them in their order. Also taking a shot at Alina Habba, saying they never asked for a jury, but they wouldn't be entitled to one either. And then he methodically went through first at the end, the remedies, but of course how he got there. The remedies are up to the $500 million or more than $500 million in total against Donald Trump, and additional monies against Eric Trump, Don Jr., Alan Weisselberg, Jeff McConney, mainly them paying back, some of those people paying back their separation payments that were the gag payments that were paid by the Trump organization. But then the big headline is the banning. Donald Trump is banned for 3 years from being an officer or director of any New York corporation, including his own, or from being in a control position. Alan Weisselberg, sure, he's banned for life for being a control officer, as in having a position where the finances run through an officer, as is Jeff McConney. Eric and Don Jr. just missed a 3-year ban. They're banned for 2 years, which means for the next 2 years plus, there's not going to be a Trump that's going to be heading any of the companies that have the Trump name on it, because there can't be by way of this ban, period, which means other outsiders not named those people have to come in and run the company, while a monitor her tenure is extended for 3 years, and the creation of a new independent compliance director, because the judge noted there are several positions within the organization, including chief financial officer, that haven't been filled in 15 months. How do you run a company without having control officers, which are exactly what it sounds like, who are responsible for financial reporting, truthful statements, financial statements, truthful statements to lenders, to counterparties, and the like? They have entire vacancies within the organization, and it can't just be run by Donald Trump. In fact, it can't be run by Donald Trump at all. So, as I predicted in a prior hot take, there was a compliance problem that needed to be solved here. The judge even went one step further and solved an appeal problem that the judge had. Because remember, or bring our audience up to date, when the judge in September granted the summary judgment on count 1, there were 7 total counts in the complaint, all for some version of persistent fraud in financial statements, persistent fraud in insurance, persistent fraud in business records, and the conspiracies around those things. The judge already found one standalone count of persistent fraud back in September on summary judgment, and then said, I'm going to dissolve the business certificates, meaning you can't operate your business at all because I'm dissolving your companies. And that issue was up on appeal. The judge, as we had anticipated, revisited his decision. That's why I think they should have argued it at the trial. Revisited his decision and said, you know what? Maybe I went too far with the dissolution. I got a better idea. I just created a 2-tier monitoring system for the next 3 years with the independent compliance director reporting to the monitor, the former federal judge Barbara Jones. Let them decide whether there should be dissolution or not. They don't even have to go back to the judge. They make their own decision if they think that's in the best interest of the estate, if you will, that they've created around this. And he expanded the powers of the monitor because during the trial, things were happening. They had to be reported to the monitor financially. Now they have to be pre-approved by the monitor. So if Donald Trump thinks he's just going to easily pick up stakes, take whatever's money left that he has, and transfer those assets all out of New York, not happening, because the monitor has the ability to stop those transactions, as does the judge in his continuing oversight, if you will, over his orders. So they're going to have to, as I said on another hot take, they're going to have to create new funds of money that aren't being generated from the existing assets or bank accounts, and put that in another state, and then try to reform there if that state allows them to be a officer or director. So you got the bans, you got the money. This is all has to be started in 30 days unless there is an appeal. Talk about that next. And then you've got these equitable remedies that we just talked about, and this implementation of a new surveillance and monitoring structure around all things Donald Trump. So he lopped the head off the leadership. He installed independent people who have to report. He fixed his appeal problem, Judge Engoron, because he took away the appeal issue, the original appeal issue. And then you've got this big money judgment where we're all wondering where Donald Trump's going to get it from, because he's only got $450 million in cash. The rest he'd have to sell, but he's got to get the monitor's approval to sell it and the like. Now, let me leave it on this. And then you guys can talk about with me also the appeal and your views. The heart of the case, just to remind everybody, is the statement of financial condition that was manufactured, as the judge likes to say, in its numbers, increasing it anywhere assets on that list for Donald Trump between 5 and 50 times their actual value. And the main chunks of assets we're talking about are 40 Wall Street, a commercial building in Lower Manhattan, Mar-a-Lago, we all know Mar-a-Lago, and what you can do there, a private residence. There's a couple of properties dealing with Donald Trump's golf courses here and abroad. There's a project with the Vornado Group that's also in there. There's Seven Springs, which is another real estate development. And there's the old post office, which Ivanka Trump was very intimately involved with. And so the judge methodically, based on the guidance given to him, the evidence given to him by the New York Attorney General, went through and figured out the following: that Donald Trump, by cooking the books in a statement of financial condition, was able to obtain loans to which he was not entitled, at rates to which he was not entitled, on terms to which he was not entitled, and the same thing for insurance. And so he disgorged or ripped away all of the profits or all of the improper economic terms that Donald Trump was not entitled to, and said that is the amount of the disgorgement. Some people wonder in our audience, where's that money go? Well, when Donald Trump finally pays it, it goes back to the people of the state of New York. It goes back to the New York Treasury. It doesn't go back to Deutsche Bank, who was misled by Donald Trump, or the insurance companies, or any of the other lenders. So that's why the victim analysis doesn't work for Donald Trump. The victim was the state of New York and the financial markets. And that money would come in into the general treasury of New York to be used for whatever they're going to use it for. But it can't stay with the fraudsters. You know, people are like, well, where would it go? Well, it doesn't stay with Donald Trump. And that's the heart of it, because each of the properties and witnesses that are outlined in the judgment all come down to the same thing. Donald Trump gave false information to his accountants and his auditors through Alan Weisselberg and Michael Cohen and others that was used and relied upon, although it's not a requirement of the law, by banks in lending him money. More importantly, not just lending him money, but this issue of recourse versus non-recourse loans is at the heart of this case. And that's what I want to make sure they understand that before I'm done with my part of this. In order to get a loan at favorable rates, at low interest rates, you generally, in lending, have to give a personal guarantee. There's got to be a person behind an organization, even if the organization on paper seems to have a lot of assets and viability. So no bank is going to give the same rate for what's called a non-recourse loan, which means you can't go against individuals on their personal guarantee, as they would for a recourse loan. In fact, one of the properties and transactions that the judge cited with Deutsche Bank, the difference was a 4 interest point swing. One side of Deutsche Bank was willing to give Donald Trump a major loan, huge loan, on a non-recourse basis, meaning not going after Donald Trump if there was a default, at 8%. But if he gave a personal guarantee, they were going to lower it, another division of the bank, to 4%. That, over millions and millions of dollars, is a huge savings in interest. So he said, okay, I'll do the personal guarantee. What they knew or should have known is, what they didn't know, but they should have known, is that it was based on fraudulent statements of his wealth, of his statement of financial condition, of his liquidity, meaning the amount of money in cash. And even when the bank said that whenever we deal with commercial developers, we automatically think they're BSing us, and we cut the number in half, 50% haircut even that means that gave incentive, because of course Donald Trump being in the business for 50 years, Donald Trump knew that they were giving him a 50% haircut, so he tripled and quadrupled and 50 times the amount of his assets, knowing that even after the 50% haircut, he would meet the criteria required to get the loan on a recourse basis at a lower interest rate. That, as complicated as it may sound, is at the heart of the case. And that's why the judge was able to say, and that's why you made an extra 50 million, 80 million, 112 million, 130 million on each of these projects. And then I'll leave it on this. Michael Cohen came out a hero in the judge's order. He said he was a lead witness, although not the only witness, because what Michael said, even though he committed perjury in the past, was backed up and supported by other credible evidence, corroborating evidence that bolstered Michael's testimony. By contrast, all of the from Ivanka to Eric to Don Jr. to Don Sr., Donald Trump, were all considered to be completely impaired in terms of their truth telling, including Ivanka. And of course, Alan Weisselberg and Jeff McConney, basically the judge said they flat out lied to him on the stand, and he found them to be completely not credible, as opposed to all the witnesses for the New York Attorney General, which all came out, including witnesses that still work in the Trump organization, that came out very strong in favor of the case. An amazing result. You guys, we need to talk about what happens next with the appeal, but that's sort of the overview.
Let's get right back into it. We were talking about the New York Attorney General's civil fraud verdict handed down on Friday by Justice Arthur Engoron. Sure, Karen, the headline was that $364 million verdict, about $355 million or so against Trump. You add up $4 million with Don Jr., $4 million against Eric, $1 million here, $1 million there against the COO and former CEO. You put it all together, you get that 364 number. But also you have to include prejudgment interest as well, which starts at various dates based on the order. So it certainly looks like it could be closer to $400 million. And then you also have to factor in the compliance, the independent compliance director, who's now has to be put in place within the Trump organization, the extension of retired federal Judge Barbara Jones's contract. And you add that with the E. Jean Carroll verdict from end of January, $83.3 million. And you're looking at that $500 million number right there in verdicts currently against Donald Trump. But let me take it back to the New York Attorney General civil fraud case and get your perspective, Karen, on the outcome.
So in addition to all the things Popok just said, the things that really stood out to me, first of all, was the decision itself. It was not a typical decision or verdict in a civil case. So when we saw, for example, the E. Jean Carroll verdict, that was just a jury that came out and said that we find Donald Trump liable and there's a dollar amount. It's not a 90-something page decision where they go through in painstaking detail exactly what they did and why. And so this verdict, this decision that the judge rendered was just absolutely painstakingly methodical, and I would say bulletproof from an appellate standpoint. He went through every single piece of evidence, every single witness, and he went just detail by detail and described what witnesses he found credible, which witnesses he didn't, what evidence they found credible. And it was just unbelievable how he did that. And the credibility findings are important because many things are appealable from a trial when you appeal something. But a credibility finding by a judge is actually one of the things that is not appealable. The appellate courts do not second guess that. And so he made sure he was very clear about not only what witnesses he found credible, but what testimony he found credible. And then again, he went through each and every element of the offenses and the witnesses and the evidence, and he explained exactly how certain factors were met and certain factors were not. And so I do think his decision really has, it was also beautifully written. He's a very, he's a beautiful writer, and he loves to quote put famous quotes in. Like one of them was, the Alexander Pope quote that said, "To err is human, to forgive is divine," but that seems to be lost on Donald Trump, who to this day, including after the verdict, and he went out and gave a press conference at Trump Tower, basically said, "I did nothing wrong." He shows no remorse. And Judge Engoron essentially called Donald Trump, I think he said, he called him close to a sociopath, or it was almost pathological, the way he lies and continues to lie. And so those were the things that stood out to me the most, was just how frankly appellate bulletproof this verdict is for those people who are worried about an appeal. Number two, he's going to have to put up a significant amount of money in order to appeal. Some say he has to put up the entire amount to appeal this case, and really have to park it, in a bank account so that the appellate courts will review it. Another thing that I thought was really stunning about this decision was the fact that he's unable to borrow money from any bank or financial institution. He can't take out any loans that are chartered in New York. And for those people who say, "Oh, well, then he can do it somewhere else," New York City is the financial capital of the United States of America, if not the world. And Popok just said chartered or registered. Thank you, Popok. Every single bank is going to be registered in New York, because this is where the Federal Reserve is located. And so that's why the Manhattan DA's office, for example, always does these big white collar cases, not because the Manhattan DA's office is better than anybody else. Anyone could do them. It's that the crime scene, if you will, of all these financial cases flow through New York, because every United States dollar that is transacted anywhere in the world actually flows through Manhattan, where the Federal Reserve is, and that actually gives them jurisdiction over these cases. So by putting that in there, it severely limits Donald Trump's ability to do business in U.S. dollars. Apparently, I guess he could do private loans or get private equity from people. But in terms of banks or financial institutions, he is out of business for several years because he can't take out those loans. And then the final thing I just wanted to comment on, and I want to end it with a question for Popok, is the thing that I thought he did that was so brilliant, Judge Engoron, is Judge Engoron has been taking a lot of criticism from Donald Trump throughout this trial, as we all know, because he calls everything into question and he lies about him, and he says, he's the most reversed judge. I mean, he gets reversed. Some judges get reversed. That's what happens sometimes. But, on and on about how he's unfair. He hates me. He had his mind made up ahead of time. All the things that Donald Trump says about Judge Engoron, and he's made it personal. Judge Engoron has installed by name Barbara Jones as the independent monitor of the Trump organization. He didn't just say an independent monitor. He actually named Barbara Jones, who is the independent monitor who's been working on this case or who's been overseeing this matter since Judge Engoron appointed her. By appointing her to do this, he has essentially made this bulletproof again. Why is that? Because Barbara Jones is one of the most respected people, lawyers in probably the United States of America. I personally, when I was a very young prosecutor back in the day, she was the chief assistant, which is the job that I ultimately had many years later. I didn't ever work directly with her, but she had a reputation. She was sort of one of the people that people revered and that women like me looked up to and said, wow, she set the standard. She set the bar for just really a good lawyer, an ethical lawyer, and a smart lawyer. And she was so good that she eventually left and was appointed to be a federal judge, right? An Article III judge in the United States Constitution. It's appointed by the president, confirmed by the Senate. And she was a federal judge. Again, as a federal judge, respected beyond measure and beyond reproach. And at some point she retired and went into private practice. And she now is one of the, like everything else, she's one of the most respected go-to lawyers there is. And so the fact that he installed her as the independent monitor, he has taken himself out of the equation. It is no longer, what does Judge Engoron think? It is no longer Donald Trump versus Judge Engoron. This is now Barbara Jones, who's going to be reporting what she sees. She's going to be able to look into the books and records of the Trump organization and look with a microscope and report back to the court. She's an officer of the court as a lawyer and as an independent monitor. And she's going to report back her findings, and she is going to report back anything that she sees that is untoward or in any way in violation of the law or in violation of Judge Engoron's orders. And by doing that, it is no longer it takes away this ability for Donald Trump to say, Judge Engoron hates me, Judge Engoron this, Judge Engoron that. And I've never heard Donald Trump attack Barbara Jones, which I find very telling, because there's really nothing you can say about her. She is widely respected by both sides of the aisle. And she is somebody who I thought that was the most brilliant move that Judge Engoron did in this entire decision. I have a question though for you, Popok. If she does see something that is in violation, what can happen? Does she just report it to Judge Engoron? Do they then have to bring charges and have a trial, or can he just swiftly make a decision and respond?
That's a very good question. I mean, what he's leaving in place, we'll get Ben's view too. What he's leaving in place is a self-monitoring system with a combination of the monitor, who you've done a great job outlining who that is and what she's been doing in terms of her giving frequent reports to the judge during the pendency of the trial. She'll continue to have reports. I mean, monitors almost never, whether they're receivers or monitors or trustees, regardless, depending upon which forum you're in, they report to somebody. And normally that's a judge. So the judge, even though it's not listed in his order, is going to retain jurisdiction over this matter for as long as the monitorship exists, which is at least 3 years. Even if Eric and Don Jr. get back into a driver's seat after 2-year ban is over, there's still going to be this monitor who's going to be not running the day-to-day operation, but supervising it and monitoring it. And so she's going to continue to report to Judge Engoron for as long as he's on the bench, or whoever is in that division at that time, as a consistent oversight over this. And if the judge doesn't like the reports, just like a bankruptcy judge has continuing jurisdiction over a bankruptcy estate, you're going to see hearings that break out on this, and new punishments, new fines, new repercussions, even post-judgment in terms of the judge's powers, which is consistent with 63-12. That's why, just one last thing, I'll turn it over to Ben. That's why I know in the chat there's some conversations, because we had raised the issue. We teed up the issue of Alina Habba not having a problem about Alan Weisselberg, who may still be pleading guilty to perjury before the Stormy Daniels case in March that we're going to talk about during the podcast. But she's not out of the woods yet, because just because the judge didn't think it was interesting to put it in his 92 pages on his judgment, just as he didn't think it was interesting to comment on the potential perjury charge for Alan Weisselberg, because he had enough, having watched Alan Weisselberg, to conclude that Alan Weisselberg was not credible in the course of the trial, doesn't mean that the judge is done with all things in Trump world. He isn't, and I don't think Alina Habba is out of the woods yet either.
Look, Donald Trump may not have been posting about retired federal judge Barbara Jones and attacking her the same way that he does with Justice Arthur Engoron, but recall that Donald Trump's lawyer did attack Barbara Jones quite forcefully And I thought it was a massive mistake to do so. Remember, back on January 26th of 2024, Barbara Jones sent the final report to Justice Arthur Engoron that identified inconsistent financial statements, erroneous financial statements, incomplete financial statements, that Donald Trump and the Trump Organization was no longer even using statement of financial conditions. They were no longer even certifying that their accounting was being done pursuant to generally accepting accounting principles anymore. And the response to that from one of Trump's lawyers, Cliff Robert, in this letter that was sent on January 29th, 2024, was to say about retired federal judge Barbara Jones that there is serious doubt about her competency, that it raises serious doubts on the monitor's competency. And then Engoron, in a footnote in this 90-plus page order, addressed that. It's footnote 56 on page 86, where Justice Engoron talks about how the court did not appoint Judge Jones randomly or arbitrarily or by happenstance. Rather, she was the only one of the three candidates that both sides proposed for the position of independent monitor. However, she issued her scathing January 26, 2024 report, quite critical of defendants' financial practices. Then defendants changed their tune. Overnight, a universally respected former judge with a stellar resume nominated by defendants themselves joined the ranks of all of those people and institutions being unfair to defendants and out to get them. So now you have, as the monitor, somebody whose reputation was just tarnished or attempted to be tarnished. You can't tarnish her reputation. Attacked by Cliff Robert. She's now going to be making a lot of these important recommendations. That just goes to show you also, I think, the very bad lawyering and bad kind of strategy there by Donald Trump. You don't do that to the independent monitor. You especially don't do that to retired federal judge Barbara Jones. And she's not just a retired federal judge anywhere. She was a federal judge in SDNY and one of the most respected judges there out there. So from an appellate perspective, if you wanted to try to argue, hey, Justice Engoron doesn't have all of this credibility and Justice Engoron this, okay, well, now you're also attacking retired federal judge Barbara Jones from the SDNY. Any appellate court, the Supreme Court of the state of New York, which is actually called their Court of Appeal there, whatever it is, they're all going to look at that and go, whoa, whoa, whoa. If you're attacking Barbara Jones, we're going to make sure that that is nothing. It's clearly a you problem if you're going after Barbara Jones.
Well, if you like legal shows where lawyers are lawyers who know what they're talking about at the intersection of law, politics, and justice, you've come to the right place. Legal AF, only on the MeidasTouch Network. 2 million strong. Legal AF every Wednesdays and Saturdays at 8 p.m. Eastern Time on YouTube and then on audio podcast platforms of your choice. We do that kind of analysis related to 4 or 5 topics you need to know at the intersection of law, politics, and justice every week, twice a week. And then we do hot takes like this one to bring you up to speed in real time about any developments in between the podcast. If you know all about Legal AF, thank you for being with us. We thank you from the bottom of our pod. If you have no idea what I'm talking about, that was Legal AF, and I'm Michael Popok. And we invite you to join us as be a part of our audience on Wednesdays and Saturdays at 8 p.m. and then on our audio podcast platform of your choice. So until my next hot take, until my next episode of Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.